Hi everyone, this is Dr. Nilesh Patel. Welcome to the introduction to pharmacy law. So this is really a brief overview, or really an introduction to the basic legal system within the UK, so you have an understanding of how that applies to medicines and certainly to the profession of pharmacy. So we'll cover the basics around the Human Rights Act and the Equality Act, because that has an impact upon what we do as healthcare professionals. And then also in terms of medicines in particular, we'll briefly go over the Medicines Act as it was and the Human Medicines Regulations, which is the big one around medicines manufacturing, use and distribution. So we'll go over each of those in turn and a few other kind of key legal things that we need to think about and consider when we work as pharmacists. So a lot of this will be touched upon again as you progress through the MPharm, but this is really just an overview of the law, so you get an understanding of where it comes from and how it's relevant. So, I mean, I suppose from the basics, since 1973, when the UK joined the EU, a lot of the legislation relevant to pharmacy and medicines were derived from the EU. So until Brexit, the EU, or the Europe rather, was the highest legal authority for such laws in the UK. So laws that came from the EU had to be enacted into our domestic legislation. So basically, we, as the UK, we had to try to incorporate the law into our own systems in one way or another. So that was the way it happened before. Obviously, since Brexit, things are changing, but we still, we still haven't. Well, time will tell in terms of how things will change. So as I say, at the moment, things are kind of up in the air regarding what's going to be changing in terms of medicines legislation in particular post Brexit. But at the basic level anyway, so we think about UK law, so domestic legislation is what I mean. It does operate at two different levels. So that's primary legislation, which is really the main kind of primary authority for legislation within the UK, and these are acts of parliament. And then the secondary legislation, which is really what adds kind of substance to the main acts of parliament. So it's a kind of fine detail around what should be done, what can't be done, and things like that. And they are sometimes known as statutory instruments, which we'll talk about briefly in the next slide. But strictly speaking, there is no such thing as pharmacy law. So there's no separate entity called pharmacy law. It's just that the profession and individual pharmacists are subject to general law, but a lot of those aspects are directed specifically to pharmacy and pharmacists, or have an application to us as a pharmacy professionals. So hopefully I'll make that clearer as we go through the lecture. So there are different types of law. I suppose the two main kind of divisions of British law are the statute law and common case law. And I'll kind of focus on elements of both of those over the next few slides. So law is basically what I talked about in terms of primary legislation. They are acts of parliament. So they can be public or private acts, and the public ones are the ones that really affect us as pharmacists. So public acts of parliament include things like the Medicines Act, the Misuse of Drugs Act, which is quite important in terms of controlling illicit drug substances. And you'll hear more about that over the next couple of years or so. But these acts, as I said, are called primary legislation. So these are acts that give powers to the government to do things. So statute law really implies rules made by the state, but that prescribe duties and obligations between the citizen and the state. So it's a set of obligations that the government has to us as people, and people have to the government. So the programme of primary legislation is usually outlined in the Queen's Speech, which you may have heard about. and that's when Parliament enters a new session every autumn. So in the Queen's speech, the programme of primary legislation, i.e. the new Acts of Parliament, are laid out. So that's quite an important period in terms of what's going to be new in terms of new law. Now, when these acts how these acts come about is through several stages actually. So you don't just submit an act. It does come through several processes or several kind of what I would say kind of sessions. So the first one is a discussion document. So it might be a green paper that comes up with an idea for a new act, and then before that bill or act is proposed, then the government will usually signal its intentions with a white paper. So this is really a bit more detail around what the government is proposing for the new act or the bill, and what they're going to be doing around it. So that goes through various stages of discussions. It goes through lots of readings and debates before a bill even becomes an act. So usually before something becomes an act, it needs to go through both House of Commons and Lords, and they both have to agree to propose that bill as a new act. So there is various stages that things go through. So it's quite difficult sometimes, and it's a kind of arduous process to get things changed within government, because it has to go through these various stages. So you don't necessarily get fast tracking of acts unless maybe there's a national emergency like we've had with COVID, but otherwise it is kind of a bit of a long process. So that's statute law. So within statute law, you've got things like public law. So these are basically involving the state, or basically we'll just say the government, same thing as far as we're concerned. And these, as I say, public law tends to be mostly statute law. It can be common law, which we'll talk about later, but it is mostly statute law. And the one that we all know about is criminal law, basically. So criminal law is a subset of public law. And criminal law, as you'll appreciate, defines the boundaries of acceptable conduct. So contravening this law means it's an offence against society and it's punishable by the state. So that's fairly kind of straightforward in terms of our own understanding of what criminal law is. And the criminal laws that affect pharmacy are things like the Human Medicines Regulations and the Misuse of Drugs Act. So any breaches of those laws would mean that you've broken the criminal law, and that is punishable by the state. Okay, so as I say, worst case scenario is you go to prison for that. Otherwise, you may end up getting a fine as the kind of minimum, but any breaking of the criminal law, so i.e. in our case, Human Medicines Regulations and similar sort of medicine related acts, can mean that we can get in trouble and potentially go to prison. Criminal law, certainly in England and Wales, the Crown Prosecution Service makes the decision whether they're going to prosecute somebody who's alleged to have committed an offence or crime. So remember, it's innocent until proven guilty is usually the way criminal law works. So you're alleged to have committed a crime, but it will be the Crown Prosecution Service who makes that decision as to whether to prosecute you for breaking or allegedly breaking that law. Within the criminal law, and in terms of who regulates it from a medicines point of view, you've got the MHRA, which is the Medicines and Healthcare Regulatory Authority, and they're the big government agency responsible for enforcing medicines legislation within the UK. So they can bring forward criminal prosecutions in cases of things like unlawful manufacture of medicines or supply or promotion of medicines. Then obviously you've got the General Pharmaceutical Council, the GPHC, and they can prosecute us for certain types of provisions of medicine offences. So again, we could get into trouble not just with the government, but also with the GPHC, which would then potentially affect our registration practice and ability to practice as a pharmacist. Another subset of law is administrative law. So administrative law regulates activities of public bodies. So every NHS body and clinical commissioning groups, so these are groups that look after GP practice budgets, prescribing budgets and things like that. So these bodies, public bodies, are set up as by individual regulations under an enabling act, so it's under administrative law. So it basically controls, gives them a bit of autonomy to do their own thing. So it gives them some statutory powers, such as powers to manage budgets or hire and fire staff or enter into contracts. Now, from a pharmacy point of view, certainly from a community pharmacy point of view, the one that's probably more relevant is the NHS dispensing contract terms of service, which is enforced by NHS England, so they would be the public body. So every community pharmacy has got a contract and they have to follow that terms of service. Any breach of that terms of service would be breaking the law. So again, something quite important to bear in mind. And the example I've given in the slide is just where a firm breached a contract with an NHS body and effectively lost their contract as a result. So this kind of shows that the element of the statutory powers that every NHS trust has through administrative law to basically manage their own budgets and set up contracts. So that's what administrative law is. Professional law is well, it's really what part of what governs us as healthcare professionals. So it's laws that allow disciplining of health professionals. Now, as I said, the GPHC is our governing body. They are our regulatory body, and they are constituted within statutory law. So they come under the Pharmacy Order 2010, which, as I say, is statutory law. So, and within the Pharmacy Order 2010, there's also the Pharmacist and Pharmacy Technicians Order 2007, which gives the GPHC the power to discipline pharmacists and technicians. So the GPHC does have some statutory powers of their own, and it allows them to do things like fitness to practice procedures, which you will have heard about or will hear about. And certainly from the university point of view, we've got the university fitness to practice, but we've also got a pharmacy specific fitness to practice. So if you get in trouble for various reasons, then you may be asked to come to a fitness to practice investigation meeting where we will kind of judge you in terms of what would be expected of a pharmacy professional. So you've come across the standards of pharmacy professional. So Rav Savania talked about it. I also reiterated it again in my Welcome Week talk. So the kind of standard or the rules that we have to abide by and what we judge by are the GPHC standards for pharmacy professionals. And remember that applies to you as pharmacy students or students in training, pharmacists in training. So anything you do within university and outside of university will be judged according to the GPHC standards for pharmacy professionals. And as I said, it's, we use standard of care to judge whether somebody is guilty of professional misconduct. So the decisions are based on the balance of probabilities. So it's what I mean by that is it's based on civil law standards of proof. So it's not on the beyond reasonable doubt, which is what criminal law is. So with criminal law, you have to prove beyond reasonable doubt that somebody has done something. But with civil law and certainly professional law in terms of tribunals and stuff, the decisions are reached on the basis of the civil law standard of proof, which is on the balance of probabilities somebody is likely to have done or breached professional misconduct. Okay, but as I say, the bit that where this comes into play is when we talk about fitness to practice hearings and procedures. So to reiterate, as I said, FTPs or fitness to practice are The big thing, and I've just given some examples of cases, and there's lots of these actually. If you're interested, if you go to the pharmacyregulation.org, they publish all these fitness to practice committee hearings. It's kind of like a name and shame in a way. So it does say what the problem was, what the breach was, what the FTP issue was, and who had breached that or who'd been under scrutiny at that case. So it is a kind of a name and shame. But there's various different examples. So there's things like dishonesty, and that's a big thing as well. So it's kind of owning up to your mistakes or things you've done and not lying about it, fraud, plagiarism. So again, that applies to you guys this while you're in university as well. And things like dispensing medicines without a prescription, which again is against the law. It breaches the Medicines Act and the Human Medicines Regulations, or failing to keep records or even due diligence around handling and supplying medicines. So these are where you could be put under the Fitness to Practice Committee, and the GPHC may either just give you a slap on the wrist or a warning, or in worst case scenarios, take you off the register and stop you from practicing as a pharmacist. Okay, so that's a lot of that was kind of more under the statutory arm of the law. But let's talk about the other main division, which is common or civil law, used synonymously sometimes, and I'll probably start talking more about civil law, because that's the one that's kind of more commonly referred to. But common law in general, it relates to duties and obligations between citizens. So it's not like statutory law where it's between the citizens and the state. This is actually between citizens, so citizen to citizen. And common law or civil law has been developed from decisions of senior judges in the courts rather than made through Parliament. So principles of common law have been developed as a result of cases heard over many years. So it's what we call judge-made law. So over the years, there's been various things that's happened. Judges heard various things through the courts, and then over that time, you get these decisions, which then starts to become civil law. So it's based on experience, based upon previous kind of situations and cases. So this is what makes it different to statutory law. And it's really common law that it relates to specific circumstances when legislation does not exist or apply. So judges have to use their own experiences and previous experience through previous decisions around what they should do. Okay. Now, from a pharmacy perspective, an example is that a pharmacist has a common law duty of care to their patients and public. So this common law duty of care is what we are judged by as healthcare professionals, and that's a duty of care to patients and the public as a whole. So that's quite important to bear in mind as well. So as I said, civil law, and I'm going to talk about civil law rather than common law. That's probably more familiar and more common. So it's concerned, as I said, with disputes between individuals or organizations, and that's regarding duties, rights, or obligations. So for example, property law or property disputes could be around land disputes or copyright infringement, trespass, for example. So trespass is actually a civil law, believe it or not. So whenever you hear that thing about, oh, trespassers will be prosecuted, that's not actually true, because it's not, because trespass is a civil law, so trespassers cannot be prosecuted, but they can be sued if they cause damage. So that kind of signage that you might see is not quite true. But if you did cause damage, then that it will come under civil law. But trespassers cannot technically be prosecuted because it's not criminal law or statute law. And then you've got things like law of contract, negligence and defamation. So negligence and defamation, and also breach of confidence, they're the ones that are the most common within healthcare practice. And negligence we'll talk about shortly, but that is a really important thing that we need to think about from a health point of view. If you do read around the subject as well, you'll hear the word tort which is basically a French word for civil wrong. And it's really just a way of defining a wrongful act committed against another person, whether intentionally or not. So again, if you do read around civil law, you will hear the word tort mentioned quite a bit. But it is, as I said, around everybody owing each other duties and responsibilities, and any breach of that, and that could be a breach of duty arising out of a personal relation or contract, comes under civil law. Okay, so in civil law, in a civil case, what happens is effectively the complainant makes an allegation that the actions of another person has caused them damage or injury. So whoever has had something wrong done to them, they have to bring that case forward. Okay, so it's the complainant makes an allegation that somebody else has caused them damage or injury. I suppose the thing that you guys probably will be familiar with more than not is actually things like Judge Rinder. So if you ever watch Judge Rinder, then those are civil law cases where you've only got one judge. There's no jury. It's in a basic court, and you'll see that somebody has brought up a case and they are stating their case against somebody who's done them wrong. So effective. So yeah. So if you basically picture things like Judge Rinder, that's what civil law is at the basic level. So it's where somebody states their case that somebody's caused them damage or injury or owes them some money or has breached a contract in some way. So before it even goes to court anyway, most civil cases are settled out of court to avoid legal and associated costs, because it's not cheap to go to court. So a lot of these things are settled out of court in general. But as I say, the complainant then has to prove their case on the balance of probabilities, which I talked about earlier. So i.e., it's more likely than not that the other person did cause them harm. So as I said, that's different to criminal law, where it's beyond reasonable doubt. This is actually, it's more likely than not when it's civil law. Okay. And as I said before, negligence is one of the key things that people can get into trouble for. So it's worth you guys bearing this in mind, and we will cover negligence over the next few years. But negligence, some examples of this, as you start thinking about the practice of pharmacy and learning more about pharmacy, is, I suppose the most simpler examples that are relatable are things like supplying the wrong drug to a patient who then suffers harm as a result of that error. So those of you who worked in a pharmacy, whenever you dispense medicine, you realize there should be checks in place to make sure you don't give the wrong medicine out to the wrong person, or to even the person who it's intended for. And you'll be doing dispensing classes starting next term, so we will be drumming into you around being accurate and not making mistakes or errors. And another example is where we haven't done any due diligence. So a doctor prescribes too high a dose of a medicine, and then we don't pick up on that, and then we end up dispensing it and giving it out to the patient, who then suffers harm as a result. So these would be considered negligence because we haven't done or shown a good duty of care or demonstrated a standard of care that's required by law. So in order to establish negligence, there's three things that must be proven. So the first thing is duty. That duty was owed to the patient in that particular situation. So we have that duty of care. So we have that duty not to supply the wrong drug or to pick up on things like overdoses and things like that. And that there was a breach. The second thing is that there was a breach of that duty. So the professional breached that duty in failing to conform to the standard of care required by law, and that there was a causation, so that the patient suffered harm as a result of our actions. So you must prove three things: duty, breach, and causation. and those are quite important within civil law. And as I said, the kind of unfortunately the case is that, okay, you can be done for negligence if somebody comes to harm, but if somebody dies as a result of your negligence, then that comes under criminal law. So that's a breach of the human medicines regulations, and you will then be prosecuted by the courts, and that's a different set of laws and court hearing. So you can get into trouble for breaching or showing negligence, but if somebody dies, then that becomes a criminal act. So then you'll be prosecuted. So that's why we do tend to drum in about being very careful and accurate. So that's something to bear in mind. Now, I thought I'd still mention EU law just to give you a bit of context and history. And I think people have got different views on the EU and Brexit and things like that. But I think a lot of people don't necessarily have an understanding of where laws came from and how they were implemented. But I thought I'd just give you some basic history or background, because I'm not sure what's going on at the moment regarding what the government's going to do around certainly medicines related legislation within the UK, because there was a lot of good things coming out of the EU. It wasn't all bad, and we're not quite sure what's going on. So one of the examples of a good thing was monitoring medicines to make sure that there was no counterfeit or fake medicines within the medicine supply chain. So there was a new system set up where you could scan the barcode of a medicine, and that would tell you whether it's a fake medicine or not. And that was EU wide, but since Brexit, nobody knows what's going to happen with that. So we don't necessarily have that added level of protection. So as I said, there was some good things coming out of it. It wasn't all bad as the government stated. And certainly from a medicines point of view, I think safety for everybody who uses medicines is paramount. But anyway, much of the UK law pre-Brexit had to comply with EU law. So the EU court made regulations which were compulsory in all their elements, and that was applicable to all EU member states. So what the EU would do would be issue directives which specified the objectives that the state had to reach, or the government, and it's really up to each government or state as to how its law was amended to comply with the directive. So the EU would give the directives, but it would still give autonomy. It would still give powers to the state to decide how they complied with the directive. So it wasn't. So that's the key thing. So the government could still kind of apply that, and the EU never really stated or gave details of how the objectives should be met or achieved. It was up to the kind of domestic member states to decide how they would apply those laws. Unfortunately, the speed at which a lot of this legislation got put into different countries was quite variable. So as I said, the speed at which this was done and the effectiveness of the enforcement of those new directives varied considerably from member state to member state, which might explain some of the kind of chaos that ensued. But within the UK, the most common means of incorporating directives in the law is as statutory instruments, which we talked about as secondary legislation. So that's how that all came about. But anyway, so that was just a basic background into EU law, because it's in some ways it's still quite important to medicines law, and who knows what's going to happen in the next year or so. So it's just watch this space. Okay, so we'll do a few more things before we have a break, and then you can start looking at part 2 of the lecture. So what I thought I'd talk about is 2 key bits of Act which do apply to all health professionals, not just pharmacists, and these are the Human Rights Act and the Equality Act. So I'm not going to go into a lot of detail for this. You'll you'll hopefully cover parts of it as you go through the program, but it is something that you should be aware of and find out more about for your own benefit in due course. So you might appreciate that human rights are basically basic rights we all have simply because we're human. Yeah, and that's regardless of who we are, where we live, or what we do. So human rights are based on a number of core values, and these include fairness, respect, equality, dignity, and autonomy. And the rights can be found in and defined by law at 3 different levels. So there's international law, which is dictated by the United Nations, there's European human rights, and there's domestic human rights. So within certainly our Human Rights Act, the domestic ones, it does incorporate the rights as set out by the European Convention on Human Rights, and that's effectively what British law is based upon. And it does require all public bodies, and that's including healthcare professions and community pharmacists, for example, and other bodies carrying out public functions to respect and protect human rights. So all UK laws, no matter what they are, must be interpreted to respect and protect the human rights of all UK citizens. So that's quite important. And the Act sets out various human rights in a series of articles. And each article deals with a different right. So there's lots of different articles, and I'm only going to show you the ones that are more relevant to healthcare. And so as I said, there's several different articles, and I'll show you the ones that are more relevant to healthcare. Now, within the rights, I should say that there's 3 main types of rights. So, and I'm not talking about the articles now, I'm talking about the rights in general. So there's 3 main types of rights. So these tend to be what we call absolute rights, limited rights, or qualified rights. Now, absolute rights cannot be limited or interfered with in any way. So that's either by NHS organisations or by any other public authorities. So an example of an absolute right in a healthcare setting is the right not to be tortured or treated in an inhuman or degrading way. So that cannot be limited or interfered with. There's no wriggle room for that. So that's an absolute right. A limited right can be limited only in specific and finite circumstances. So these are set out in full in the Human Rights Act. And so an example of a limited right is a right to liberty, for example. So that's often of relevance in things like mental health or care homes. So these are limited to a particular situation or circumstance. And then you've got qualified rights, which can be limited in a wider range of circumstances, are limited rights. And these qualified rights are the majority of the rights within the Human Rights Act. And this is because the protection of qualified rights can affect the rights of others. So basically impacting one right can impact another one. So you might say, I'm going to protect somebody's right to practice their own religious beliefs, but that might impact upon another right, which is a right to, for example, life, where if you are denying somebody treatment based upon your beliefs and that person comes to harm, then you are breaching their right for life. So that's what a qualified right is. So a qualified right protection of a qualified right can affect the right of others. Hopefully that makes sense. So another example is somebody's right of freedom of expression, and that may compete with another person's right to respect for private life. So that's another example of a qualified right. So through these key human rights, so we've talked about the right of life already. So what do I mean by that? So it's not a right to be deprived of life. Well, actually, let me rephrase that. So the right to life is a right not to be deprived of life, save in very exceptional circumstances. It's not a right to unlimited healthcare or medical treatment in all circumstances. So it's not saying, oh, no matter what happens, you have a right to get as much treatment as possible. There are exceptional circumstances where just throwing treatment at somebody is not going to benefit them in any particular way. So as I say, it's a right not to be deprived of life, save in very exceptional circumstances, but doesn't mean that you can get unlimited healthcare or medical treatment in all circumstances. It's not a right to die, and some people do sometimes talk about this right, particularly when they think about things like assisted suicide or euthanasia. So it is a right to life, it's not a right to die, which some people have used in cases of assisted suicide or euthanasia. Article 3, which is freedom from torture and inhuman or degrading treatment. So inhuman treatment means treatment causing either mental or physical suffering. Degrading is anything that's humiliating or undignified treatment. For example, it could be physical or mental abuse. So there's a right not to be abused or humiliated or degraded in any way or tortured in any way. So denying somebody treatment when they need it could be considered as torture. Thankfully, I don't think this is breached that often, but certainly within the UK, but it is something to bear in mind. Article 5 is a right to liberty and security, so it's relevant to the treatment of, for example, those with mental health disorders, but it's not a right to be free to do whatever you want. So right to liberty and security is not a right to be free to do whatever you want. There are various rules and things in place that we need to adhere to, but it does give people a right to make decisions around their own treatment. Article 6, the right to a fair trial, is fairly self-explanatory, I would think. And it's really, and an example is disciplinary procedures and a right to know what somebody's charged with or what you are charged with and be given notice of the time and place of any proceedings. So it's a right to know what you're being accused of and to make a case in your defense and know when all that's going to happen. Article 8 is quite wide-ranging. So things like private life, family life, home and correspondence. But I suppose the ones from a healthcare perspective that's of relevance is things like data protection, so keeping people's personal information protected, privacy on wards and in care homes, access to medical records, things like that. So that's I think from a healthcare perspective, that's more about privacy, data protection, access to information. Article 9, freedom of thought, belief in religion. So that's allowing people to exercise their beliefs, have freedom of thought, exercise their religion. But this is actually, Article 9 is one of the qualified rights that I told you about earlier. So practicing this right can sometimes breach or impact upon another right. So we have to be a bit careful about how this is applied, because this could affect another one of the rights if reinforced. So Article 9 is actually a qualified right. Article 2, the right to life, is an absolute right. And then Article 14, which leads on to the Equality Act, which I'm going to talk about now. That's really protection from discrimination in respect of these rights and freedoms. So it's a right not to be discriminated against when when somebody's treated in a different way compared to somebody else in a similar situation. So that's what discrimination is. So that was kind of Human Rights Act in a nutshell. So it is something to think about, and it does have a lot of relationship to being a health professional. So the last couple of slides before we have a break is the Equality Act, and this really is designed to protect people from discrimination, harassment, and victimization. And this applies in every setting. It's not just healthcare, it's anything we do. And it provides that a person must not be treated in a discriminatory way because of a protected characteristic. So there's 9 protected characteristics, and these include age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. So we cannot, anybody within these protected characteristics cannot be discriminated against, and we need to treat them as we would anybody else. So we cannot discriminate anybody based on their age or their disability or their sex or their race or religion. Okay, so that's quite important to bear that in mind. And some key terminology you need to be aware of. So discrimination comes primarily as direct and indirect. So direct discrimination is where you treat somebody less favorably because of a protected characteristic. So for example, rejecting a job applicant because he or she might be gay, or failing to offer a student a place because of his or her religious views. Or another example is not giving somebody an interview or rejecting them because of their age. So they might be quite older, so you cannot discriminate based on age. Indirect discrimination is again where you might put a provision or something in place that applies to everybody, but it adversely affects people with a particular protected characteristics more than others, and it's not justified. So you might think you've got things in place to help everybody, but because somebody's got a protected characteristic, then it actually doesn't help them, so you're indirectly discriminating them. So for example, requiring a job to be done full-time rather than part-time, although you might think that's okay, not a problem, that could adversely affect women because they generally have greater childcare commitments than men. So you might be indirectly discriminating against women if you require a job to be done full-time rather than part-time, if they've got childcare commitments. So those are things you have to be mindful of. And as I say, as health professionals, obviously we do the work, but you might be involved in terms of recruitment and things like that, and certainly managing people. So you need to be very careful for that. And certainly dealing with patients, we need to treat all patients equally, but also make sure that inadvertently we're not discriminating somebody based upon our own values or based upon somebody being of a protected characteristic. Okay, so that's really important. And then the other 2 things we need to be mindful of are things like harassment and victimization. So harassment is fairly self-explanatory, and similarly with victimization, usually it's retaliation against anybody. So we need to be mindful of that, and we have a zero tolerance policy to discrimination, harassment and victimization, not just as a profession, but certainly as a university. So if you go to the Essentials webpage and you go to, and I've given a link on the next slide, you'll see the university's policy around discrimination, harassment, victimization. So that is not something we tolerate within the, certainly not within pharmacy. So as I say, under the Equality Act, you are protected from discrimination, particularly if you're within these protected characteristics. And that's everywhere, as I said, whether you're in the workplace, using public services, so within a pharmacy, for example. So an example within a pharmacy would be expecting to get the same level of service if you're disabled. So access, for example, wheelchair access, or if you're partially deaf or hard of hearing, then there needs to be something in place within the pharmacy to allow that person to receive the same level of treatment as somebody who can hear, for example, or in terms of medicines access, obviously I think we take it for granted we can open up a box of medicines and pop out the tablets, but people with physical disabilities might not be able to do that. So we need to make sure we provide what we call reasonable adjustments or some provision in place to make sure that anybody who's has a physical disability can actually get the same level of benefit and treatment as anybody who is able to pop pills. So one way pharmacists help with that is to do what we call multi-compliance compartment aids, so dorset boxes is what people most commonly refer to, which is a reasonable adjustment. So we pop the pills out for the patient and put them into little compartments, so it makes it easier for them to take their medicine. So they're effectively getting or being able to do the same type of thing as anybody who's considered able. Okay, so that's another way that we can adapt what we do to make sure we're not discriminating against anybody, and that's usually what we call a reasonable adjustment. But as I say, it applies in a whole bunch of different scenarios and situations. Okay, so that leaves me with just a couple of questions. If you want to have a look at that before you look at part 2 of this presentation, and I'll go over the answers to this at the next part. So see you next in part 2. Thank you, guys.